Hello, everyone. This is the Injured Workers Legal Side podcast with Richard and Paul.
You're Richard. I'm Paul. I'm a licensed paralegal specializing in workers' compensation, human rights, and other areas of law. If you want to reach out to either Richard or myself or be part of our podcast, you can contact us through the links below. This week's topic is with John McKinnon, and it's about the age 65 issue. Yes, I know everybody must retire at age 65, all except for judges. But there was an interesting, this is hitting some interesting problems in the law, which John's going to talk about. Briefly, John McKinnon is basically the be all and end all about workers' compensation law, is how I would sum up his CV. He knows it all. Well, he won't never admit it, but he does. Take it away, John and Richard.
Well, let me just do a further introduction with John. He's been practicing law in the area of workers' comp for several decades. One of the cases he was involved in many years ago was a challenge at the Supreme Court of Canada on whether chronic pain should exist as a workers' compensation ailment. And John and other legal clinic lawyers were successful in that, which in retrospect was a spectacular challenge. So I did a case 12 years ago where we challenged the age 65 rule. We lost the case right up to the Court of Appeal. The reasoning was that the vast majority of workers retire at age 65, so it's quite acceptable to cut people's benefits off at age 65. So I'll ask John uh, why he's leading the charge now to have this reviewed and what the strategy is over the next few months. John?
Thanks, Richard. Thanks, Paul. Thanks for your kind words. Um, yeah, most people might be vaguely aware that for people that were injured before 1990, we had a permanent disability pension, and so there was people with permanent disabilities got a monthly payment for life, and the system was changed for injuries occurring after 1990 to the wage law system that we have now, where benefits essentially end at age 65. And at that time, mandatory retirement was lawful. People could just be told you're out the door at age 65. And so it made some sense that wage loss benefits were tied to that age. But that's no longer the case. In 2007, the Ontario government outlawed mandatory retirement. Um, and so that led to the case that Richard brought, challenging the age 65 based cutoffs as discrimination on the basis of age and contrary to our Charter of Rights. Um, and clearly, it is discrimination on the basis of age. But as Richard pointed out, the court found that based on the working patterns of people in their 60s, age 65 was a reasonable place to draw the line. It's no longer a pension for life system, so you have to draw the line at some age, and age 65 was reasonable. But whether or not we agree with that conclusion, back in 2012, I guess the decision came out. Things are very different now. Statistics show there's vastly increased participation by senior citizens in the workforce, and you've all seen that yourselves in coffee shops and grocery stores and corner stores. A lot of people over the age of 65 keep working, and a lot of it is out of necessity. The high cost of living means that people can't survive on an old age pension, and the workplace pensions are no longer as common as they used to be. So the now probably I don't have the statistics here. We do have an expert who's preparing a report on this, but probably the majority of workers continue working past age 65, and so it's no longer seemed like a reasonable place to draw the line. And we did get some statistics from the WSIB. as well about the number of injuries for people that are working past age 65. And that has just skyrocketed by about 300% in the last 10 years or so, as more and more older workers are in the workforce. So things are different from the way they were back when the facts that the court looked at in Richard's case were based on um, expert reports by academics looking at statistics for workforce participation in 2009. And in 2025, things are very different. Um, and we need to challenge that. The people are continuing to work past age 65 because they can't afford to live. And those people who couldn't continue working because of a workplace injury or illness are in an even worse situation when their compensation for lost earnings ends at age 65 and they can't survive on the old age pension. So we need to take a look at this. We have, of course, raised this with the Minister of Labor. The government can fix this with a stroke of a pen, but they haven't. Uh, and so the only recourse that injured workers have now is to go through the courts. Other provinces were more fortunate. If you look, for example, at Alberta or British Columbia, both of them originally had the same age 65 base cutoffs as we do, but they've developed workarounds where if a worker can show that they had intended to continue working past age 65, compensation can continue past age 65. And so that still gives a lot of discretion to the Workers' Compensation Board, but that does get around this arbitrary age 65 cutoff. So that's why we're doing it, Richard, because we need to do that. Injured workers are being forced into poverty when their benefits are arbitrarily cut.
What's the sort of timeline procedure that you're on at the moment?
Well, there are a number of cases, say 8 or 10 cases that either our legal clinic or other representatives such as yourself are working on, uh, taking different examples of cases where compensation was cut off because of their age, and we're taking these up to the appeals tribunal, and we are going to challenge them on the basis of being discrimination contrary to the Charter of Rights in a hearing at the appeals tribunal. And so there's no particular deadline at this point. The When you challenge the constitutionality of a piece of legislation, you need to provide an expert report setting out the facts that you rely on. As I mentioned, we're relying on the fact that participation in the workforce by older workers is significantly increased since the court looked at it last time. And so that's what limits most people who otherwise would be challenging this because the average person doesn't have the wherewithal to get an academic or a researcher to write an expert report that could be used to support the case. So we're getting that report, and we would like the appeals tribunal to look at a variety of cases, maybe 10 or 12 different situations, to see the range of ways that this can affect people. It can affect someone who was injured at age 60 and had intended to continue working past age 65, and maybe their co-workers did continue working, but their benefits get cut off. But it also affects people injured after age 65, because if you're injured after age 65, basically you can only get compensation for 2 years. So there are people, who were maybe injured at age 67 or age 69, who had intended to keep working, beyond age 70, but they were only able to get compensation for 2 years loss of earnings, and that's not enough
John,
to continue living on.
John, don't judges currently work till age 75?
I think so. And also, the federal government has recognized the change in the working pattern under the old age pension and under the Canada pension. Now, the federal government basically uses age 71 as the point at which you must start to collect your old age pension, and you can no longer contribute out of earnings into your Canada pension. Um, and that would certainly be a reasonable line for the government to draw. Instead of having compensation ending at age 65 or for 2 years, if compensation ended at age 71 or for 5 years, if you're injured after age 60, 66, I guess. So that might coincide better with the actual pattern of participation of older workers in the workforce.
I was gonna mention that you'd think the government, I was anticipating a few years ago that the government would have lifted that cap on age 65 when we had what did they call it, a shortage of labor force, a shortage of workers. But strangely, it was like a weird situation occurred, so I won't go down that road.
Well, when the Human Rights Code was changed to outlaw mandatory retirement at age 65, uh, that would have ended the cutoff of workers' comp benefits at age 65. But the WSIB made a special case for an exemption from the law, and that's why they can continue doing that. And basically, their argument, they had two arguments. One is that this is a very complicated system based on age. You can't just change the numbers. Everything has to be looked at and it has to be done carefully. And we, the WSIB, don't have time right now because the law was going to be changed in a matter of months. And secondly, they said, we don't know if we can afford this. It all has to be costed out and it's going to affect rates and everything. And we can't figure that out in time. But that was 2007, and there's no evidence that they've given it a second thought since 2007. And the reality is now the WSIB has too much money. They're giving it back to employers in billions of dollars instead of compensating workers who get injured past age 65. And that's not right and it's not fair.
And this is only started, well, I say only because we're all older here, since 1990. Prior to 1990, that didn't apply, correct?
Yes, if you had a permanent injury recognized by the Workers' Compensation Board, you would get a pension for life.
Right.
And so that gave workers some security that as long as they live, they're going to have this amount of money coming in, whatever it is, and that would either cover their mortgage maybe or cover their hydro bill or their rent or something, but they could plan on that. Um, and
So my point was is that this was created by Meredith in 1914, 1915, and has been that way for almost 100 years, and then the government changed and is using excuses not to change it back, eh?
One of Meredith's principles on which the compensation system is founded is compensation for as long as the disability lasts. And that's why we set up a permanent disability pension in Ontario. But that particular principle, Meredith, has been ignored. And you won't find it on the WSIB website where they list Meredith's principles anymore. He had some other good principles that they still abide by, but no respect for compensation as long as the disability lasts.
Well, one of the things the board did do, though, in the 80s was they had a supplement of $650 a month. And the supplement, $400 of that supplement would come to an end when the worker hit 65. So And the supplement was there because the amount of money people were getting for their pension still left them in a great deal of poverty. The what we've been doing with our clients is that if the client is over 60 and under 70, we've targeted them as someone who would want to participate in this case. And the criteria there was that it's an easier argument to make that if you're 63, you knew you were going to work till at least 70. Or if you're 66, you would work until at least 70. And the second criteria was we're looking at their income and expenses. So we had them all do an income and expenses analysis to show that they're in a deficit position in terms of paying for their rent, food, clothing, etc., with what they're getting from Canada Pension Plan, old age, and any pension plans they have privately. So we've tried to make certain that the people we're dealing with are all at financial risk and all had jobs where they felt they would be able to easily keep going until age 70. I think we have six or seven people that we're pursuing. And what we're trying to do is get ARO decisions on these cases so that we can then join in with John on his primary cases that he's bringing forth when he gets the statistical analysis from the academic expert.
Mm.
One of
Just
them, yeah, go ahead, Paul.
Sorry, Richard. Just to add to your point about expenses and the growing cost of living, especially rent, is I just quickly searched and found, according to Statistics Canada, in 2021, 32% of people using shelters in Canada were age 50 and older. That doesn't talk about people that are living in the tents or wherever. I think, to be quite honest, as a person getting older, shame we can't just stay where we are. But that's one of my greatest fears is falling into homelessness. And I think that's something that workers, especially injured workers going through this process, should think about when it comes to the age 65 issue. Thanks, Richard.
The One of the things I was supposed to do starting about 8 months ago was to follow up with the approximately 80 injured worker representatives that we have on our email list to see whether they are proceeding in somewhat similar fashion to us, Paul and myself, which is trying to get a few cases going forward to the ARO to join with John's case eventually to the appeals tribunal. And we've only had two other reps, one of whom's Paul, that has agreed and showing us that they are proceeding on this. And what I was supposed to do was call them all and try and cajole them into participating, but I haven't had time for various reasons to do this. And it leads to one of the problems that we can see in the workers' compensation arena, which is there is not enough sort of political charge coming out of the reps, coming out of the injured workers, coming out of the trade unions, etc., to try and bring this matter forward. Um, we sent out an email to all our clients, which is approximately 190, asking them to come to Injured Workers Day on June the 1st, which was a Sunday. And none of them showed up. So then over the last couple of weeks, we've been asking our clients as we speak to them, mostly it's my legal assistant Pam doing this, why didn't you attend? Given that obviously the WSIB is not treating you fairly, which is why you retained us. And there are basic problems where can't drive that long, haven't got the psychological ability to be at a demonstration, can't be outside, etc. So they've all said it wasn't for lack of interest, it's all for lack of ability, whether physical or mental. And it tells us that beyond us going to the tribunal, we're missing part of the kick to the government, which is pressure. Uh, what I was thinking was that it's too bad we couldn't get 1,000 injured workers out to Queen's Park to demonstrate on behalf of the union that's currently on strike by saying part of their reason for being on strike is they haven't got the resources to properly adjudicate claims. And and then they adjudicate negatively because that's the easiest shortcut for WSIB management. Um, but there's a large gap there. Perhaps John can address this as he's tied in as much as anyone.
Yeah, well, it's our experience that most workers with a permanent injury are feeling very, very defeated. Defeated by the workers' compensation system and defeated by being disabled and without income and suffering economically uh, and don't really necessarily see a way out. And I think similarly with a lot of representatives, they're representing people within the existing law, and don't see a way to change the law. But one of the things that we've seen through the decades is that fighting back works for injured workers when there's an unfair system, and so that's uh, s- something that people have to learn is that there is something that you can do about it. People can stand up and write to their MPPs and bring their situation to the attention of the legislature and the government about the unfairness of the law, and the laws can be changed. Um, you know, uh, you mentioned the chronic pain case, and that was a case that started out with the Nova Scotia Workers' Compensation Board, and they changed the legislation to provide that uh, compensation for chronic pain disability was only allowed for 6 months because it can be cured within 6 months, and that was challenged. And the Ontario Network of Injured Workers Groups also participated in that. Talked to a lot of medical experts who like we f find that people with chronic pain have permanent injuries, and often, despite the best efforts by the medical profession, they can't be cured. They can't be made better. It's a lifelong disability, and we were able to prove that to the court. Um, and the court said, yeah, this is discrimination on the basis of your disability. If you've got an amputation, it's a lifelong disability, and you get compensation for it. Chronic pain can be real and disabling, the same as an amputation or any other work injury. Um, the courts can be persuaded that the law is unfair and needs to be changed, and sometimes the government can be persuaded as well. Um, but it takes people standing up and showing their situation, talking to their MPPs and the Minister of Labor, and so people need to learn more about this situation, and we need to get in touch with more workers who are facing this situation. And one of the things that our legal clinic is doing to kind of spread the word is we're having a Know Your Rights session coming up on Wednesday, June 25th. It'll be a hybrid session. People are welcome to drop into the clinic in our meeting room and join it, but people can also join it online. And at that session, we're going to talk in more detail about the legal issues in terms of what unfairness do older injured workers face, and also at some of the solutions. We're going to talk about people who might want to join our challenge and take their case to the appeals tribunal. People might want to speak to their member of provincial parliament about the situation and ask the government to change the law. So it's definitely a long process, um, but it can work. Unfair laws can be changed either by political pressure or by the courts, and it just takes time and attention to make that happen.
Well, I'd like to thank John for coming out today. Please send us again email of the notice for the June 25th. We'll try and distribute that out.
Okay.
And wish all our friends watching this a great week, and we'll see you next week.
Thanks for coming, John.
Okay. Well, thanks. I've enjoyed talking about this, and take care, and we'll talk to you again.
Bye bye.
Bye for now.